Good morning and welcome to the South Carolina Public Service Commission. It is approximately 10:15 on Thursday, March 12th, 2026, and 10 a.m. Present in the hearing room, Commissioner Britt, Commissioner Caston, Commissioner Henley, Commissioner Whitfield, Vice Chair Williams, and I am Delton Powers. Commissioner Belser is on leave today and will not participate in this morning's hearing. We would first like to welcome Commissioner Henley. This will be his first meeting. He is joining us, and we look forward to working with him and have him on our team. All right. Mr. Scarborough, if you would, please proceed with our docket.
Yes, sir. Good morning, Chair Powers, Vice Chair Williams, and Commissioners. First order of business is to set the date of the next business meeting. Staff recommends that the next regularly scheduled Commission business meeting be set for Thursday, March 26, 2026 at 1 o'clock p.m.
The next business meeting will be Thursday, March 26 at 1 o'clock.
Thank you, sir. Today there are 14 items on the utilities agenda and 3 items on the transportation agenda. Item number 1 appears in docket number 2025-300E, and all commissioners, with the exception of Commissioners Henley and Whitfield, are eligible to vote. This is a petition from Mr. Michael Wren to intervene out of time in this docket.
That's item number 1. Is there a motion?
Mr. Chairman,
Commissioner Britt.
I move that the Commission deny the petition to intervene.
All right. Having heard the motion by Commissioner Britt, is there any further discussion? Hearing none, we'll proceed to a roll call vote, beginning with Commissioner Britt.
Aye.
Vice Chair Williams.
Aye.
Commissioner Caston.
Aye.
I vote aye. The motion carries.
Item number 2 also is in docket number 2025-300E, and all commissioners, again with the exception of Commissioners Henley and Whitfield, are eligible to vote. This item involves final disposition of this docket.
That's item number 2. Is there a motion?
Mr. Chairman,
Commissioner Britt again.
this agenda item concerns the application of the South Carolina Public Service Authority requesting a certificate of environmental compatibility and public convenience and necessity to construct and operate the Kingstree Hemingway 230 115 kV transmission lines and associated facilities in Williamsburg County. The project will be rebuilding of the existing Kingstree Hemingway 115 kV line into a double circuit 230 115 kV transmission line. The proposed project is subject to the Utility Facility Siting and Environmental Protection Act found in Title 58, Chapter 33 of South Carolina Code of Laws. Based on the evidence of record and the provisions of the Siting Act, I move that the Commission find and conclude that Santee Cooper has demonstrated, and the evidence from the hearing supports, the project meets the requirements of the Siting Act for approval of a certificate. Accordingly, I move that the Commission approve the application submitted by Santee Cooper and grant a certificate for the project. The approval granted herein is subject to the applicant obtaining all federal, state, and local permits, consultations, and certifications. Finally, I move that the Commission deny any outstanding motions and/or petitions for the reasons that will be set forth in the Commission's forthcoming order. So moved.
Thank you, Commissioner Britt. Is there any further discussion? Hearing none, we'll proceed to a roll call vote, beginning with Commissioner Britt.
Aye.
Commissioner Caston.
Aye.
Vice Chair Williams.
Aye.
And I vote aye. The motion carries.
Item number 3 is in docket number 2025-247E, and all commissioners, with the exception of Commissioners Henley and Whitfield, are eligible to vote. This item involves final disposition of this docket.
As to item number 3, is there a motion?
Commissioner. Mr. Chair.
Vice Chair Williams.
Thank you, Mr. Chair. Mr. Chair, fellow commissioners, I move that the Commission find that the 2024 Competitive Procurement of Renewable Energy Program filed by Duke Energy Carolinas and LLC and Duke Energy Progress LLC should be approved pursuant to the applicable provisions of the South Carolina Energy Security Act of 2025 and Commission Regulation 103-823. Based on the evidence of record, I move that the Commission find that the 2024 CPRE program solicitation issued in August of 2024 was designed to procure needed solar and solar paired with storage resources, and the implementation of the solicitation resulted in a fair, open, transparent, and non-discriminatory procurement. I move that the commission find the evidence in this proceeding demonstrated that consistent with legislative findings outlined in South Carolina Code Annotated Section 58-42-10A, the CPRE program included target volumes of new solar and solar paired with storage resources consistent with and supported by the company's 2023 integrated resource plans and as approved by the commission and subsequent updates accepted by the commission. Additionally, I move that the commission find that based on the evidence presented in this proceeding, the 2024 CPRE program has met conditions articulated in section 58-42-20G of the South Carolina Code of Laws. More specifically, the 2024 CPRE program procures resources that will serve South Carolina customers. Eligible South Carolina facilities were allowed to participate in the competitive procurement, and the results of the procurement are in the public interest and enables the economic, reliable, and safe operation of the electric grid. Finally, for purposes of the 2024 CPRE program, I move that the commission find that the evidence supports a finding that the companies have achieved a reasonable balance of utility-owned and third-party owned solar paired with storage. So moved.
Thank you, Vice Chair Williams. Is there any further discussion?
Mr. Chair,
Vice Chair Williams.
I would like to thank the companies and the Office of Regulatory staff for their presentations in this hearing. One of the key issues in the hearing for me was an issue raised by ORS, and that issue was the concern or the question, or I guess the position, that 3 utility-owned solar projects were more expensive, and that the company did not provide a quantifiable justification to explain the higher costs. That was an issue that was discussed all throughout the hearing, probably touched on with most, if not all of the witnesses, really labored with witness Salter for ORS and witnesses Shirley Smith, and Farber. And so for me to reach my conclusion, I heavily relied upon confidential exhibit number 18. Specifically, I think it was table 3. And so the bottom line up front for me, I think the company definitely met their burden by providing that table. And what's interesting is that looking at table 3, it definitely shows that the company's position is economical for South Carolina ratepayers in terms of outcomes. And I have to talk about confidential exhibit number 18 at a high level because the information included therein is confidential. Nonetheless, the question that was raised by the Office of Regulatory staff was answered for me in that exhibit. And again, I appreciate the Office of Regulatory staff position. I understand that they don't have a burden, and I definitely don't want to burden shift. And so when I compare the company's burden and what they produce to meet that burden with the observations made by the Office of Regulatory staff, I think for me, in my view, the evidence the company has met their burden, and that's why I'm supporting approval of the application. And I'm open to any questions if any commissioners have any questions.
Chair
Thank you,
Powers.
Mr. Vice Chair. Commissioner Caston.
Not so much a question, but some comments, if I may. You know, South Carolina Annotated Code that he referenced, 584220G, requires 3 conditions to be met for commission approval of an out-of-state CPRE program. 1, procured resource will serve South Carolina customers. 2, eligible South Carolina facilities are allowed to participate. And 3, the results of procurement are in the public interest and enable the economic, reliable, and safe operation of the electric grid. Pursuant to this statute, I agree with the approval of the 3 solar-only purchase power agreements, 2 solar-paired and storage power purchase agreements, and 5 solar-paired with storage utility-owned track projects selected within the 2024 request for proposals. The Office of Regulatory Staff was created by the General Assembly to represent the public interest of South Carolina by South Carolina Code annotated section 58-4-10. Subsection B of 58-4-10 provides in part that the regulatory staff must represent the public interest of South Carolina before the Commission as it pertains to concerns of the using and consuming public with respect to public utility services, regardless of the class of customer, and preservation of the combined investment and maintenance of utility facilities so as to provide reliable and high-quality service. I see this as ORS having to balance between the customers and public utilities to ensure that it meets the requirements of both 1 and 2. In ORS's comments in response to the application and subsequently adopted as a direct testimony witness Salter on page 10, ORS states, based on South Carolina law, facts provided by the company, and ORS review of the application, ORS determined the results of the 2024 RFP, specifically the selection of Sand Hill Solar, Mosley Creek, and Ponderosa Solar Center projects are not in the public interest. North Carolina law and policy drives the selection of these more expensive projects, and their selection results in an unreasonable increase in cost over and above what reasonably would have been selected. ORS reaffirms this position based on evidence introduced during the hearing and oral arguments, stating in their February 23, 2026 letter of no objection to hearing exhibits 16, 17, and 18 that Vice Chair referenced. ORS believes that these documents support its position that 3 utility-owned track systems in question are more expensive than third-party power purchase agreement track projects without quantifiable justification to explain the higher cost. The Commission was presented with evidence for the 3 more expensive solar facilities in this docket. ORS, in considering the balance required by 58-410B1 and 2, presented evidence contrary to the position of DEC and DEP. In my review of all the law and evidence, I find that ORS's evidence outweighs that of the utility. As such, I would vote to decline the approval of the Sand Hill Solar, Mosley Creek, and Ponderosa Solar Center utility-owned track solar-only projects. These 3 facilities have materially higher cost than alternative projects which were not selected in the procurement. The applicants failed to demonstrate neither quantitatively nor through concrete qualitative evidence how the reliability or safety attributes of these projects justify their elevated cost. Therefore, they are not in the public interest, and their cost and benefits should not be allocated to South Carolina customers. So respectfully, Vice Chair, Commissioners, I'm unable to support the motion.
Thank you, Commissioner Caston. Commissioner Britt.
Thank you, Mr. Chairman. I think we spent close to 12 hours in the hearing, hearing testimony from both the Duke witnesses and ORS's witnesses, and they both did, I think, an outstanding job in presenting their case. And I, like the Vice Chairman, I went back and looked at my notes, reviewed my the information I gleaned from the testimony, and I did go back and look at the tables, and it helped me make my decision that the Duke companies actually met the 3 conditions that are required to meet for the Commission's approval of an out-of-state CPRE program. Number 1, they did meet the procured resources, and they convinced me that they will serve South Carolina customers. Number 2, eligible South Carolina facilities were allowed to participate, and the results of the procurement are in the public interest and enable the economic, reliable, and safe operation of the electric grid. And it was very plain to me in that table that the Vice Chairman referenced. So I will be voting yes.
Thank you, Commissioner Britt. And I respect both opinions in this matter. It's always, I felt like a challenge to have a company serving 2 states. It's not easy for them. It's certainly not easy for ORS. And I'm sure North Carolina thinks they're subsidizing South Carolina. South Carolina thinks they're subsidizing North Carolina. And it is a delicate balance, and it takes a lot of work on all the parties. But I will have to support your motion, Vice Chair.
Chair Powers,
Commissioner Cast.
if I may, just going forward, I respect both the company and ORS. I think they both did a wonderful job. But during the discussions and when the meeting was recessed until the Friday, there had been discussions back and forth relative to information provided. Was it adequate? Was it the right information? And I don't really recall how many months there were for all that to occur, but in a 24-hour period, information was provided that it seems like probably could have provided in the previous months, but nonetheless, I got to hang my hat on something, and I can't say definitively that information was any more accurate than the other. I can't, but I understand that you three can, and I'm fine with that. So I guess it's time to vote.
Time to vote.
Mr. Chair, before we do vote, I want to make one last statement, at least from me. My position to approve the CPRE program is in no way a vote against ORS or a reflection that they did not provide superior information and that their lawyers didn't try an excellent case. As the Office of Regulatory Staff states, with all cases, the Commissioner's role and the Office of Regulatory Staff's role are separate and distinct. And I think they did an excellent job advocating for the public interest based on their theory of the case. In my role as the decision maker, I have to weigh the evidence that comes into the record and make the best decision that I can. So the legal team, the technical team, the witnesses for the Office of Regulatory Staff, I think did a great job. And two things can be true at once. I think everyone involved in the cases did a great job, but the hard job is for the folks sitting up on this dais, and it's decision time. And so just wanted to make sure that was clear.
And Mr. Chairman,
Commissioner Brett.
one last thing too, and I think that's the reason we have 7 commissioners. In this particular case, we have 4. Because we can hear the same thing, we can see the same thing, but we see it differently or hear it differently. And that's why we're asked to call balls and strikes. And not every umpire calls a strike like the fans see it or like the other umpire might see it. So, yeah. And the nice thing is that we do it in a respectful manner, and we call balls and strikes. So that's where we're going to be.
Thank you, Commissioner
Good enough.
Brett.
I'm ready.
All right. We'll begin with the roll call vote, beginning with Vice Chair Williams.
I vote aye.
Commissioner Caston.
No. Commissioner
Britt.
Aye.
And I vote aye. The motion carries.
Item number 4 appears in docket number 2025-243WS, and all commissioners, with the exception of Commissioners Henley and Whitfield, are eligible to vote. This is a letter from the Office of Regulatory Staff concerning revisions to the directive that the Commission issued in this docket on February the 26th, 2026.
That's item number 4. Is there a motion?
Chair Powers.
Commissioner Caston.
Thank you. On February 26, 2026, the Commission granted the application of Kiowa Island Utility Incorporated for approval of an adjustment in rates and charges and modifications to certain terms and conditions for the provisions of water and sewer service pursuant to the terms of the settlement agreement filed by the parties on January 30th, 2026. The settlement agreement, which was entered into by Kiowa, the Department of Consumer Affairs, and the Office of Regulatory Staff, contains a provision that the company's rate case expenses authorized for recovery are subject to true-up as part of the proposed order. The joint proposed order, filed by Kiowa and ORS, recorded the final rate case expenses as less than $1 million contemplated in the settlement agreement, which resulted in an updated annual revenue requirement of $951,371. Accordingly, ORS filed a letter with the Commission seeking modification of the Commission's February 26th directive to reflect the updated final revenue requirement. All parties agreed to the corrected figure. Therefore, I move that the Commission update its February 26th directive to reflect the updated revenue requirement of $951,371. I so move.
Thank you, Commissioner Caston. Having heard the motion, is there any further discussion? Hearing none, we'll proceed to a roll call vote, beginning with Commissioner Caston.
Aye.
Commissioner Brett,
Aye.
Vice Chair Williams,
Aye.
and I vote aye, the motion carries.
Item number 5 appears in dockets numbered 2018-321E and 2018-322E, and all commissioners are eligible to vote. This is a joint petition from Duke Energy Carolinas LLC and Duke Energy Progress LLC to wind down and sell their direct current fast charging assets, or in the alternative, for approval to continue operating the programs.
As to this item, is there a motion?
Chair Powers.
Commissioner Caston.
I move that the Commission approve and adopt the stipulation executed between Duke Energy Carolinas LLC, Duke Energy Progress LLC, and the South Carolina Office of Regulatory Staff. Consistent with the adoption of this stipulation, I move that the Commission find that it is reasonable for DEC and DEP to wind down the DCFC pilot programs and sell the DCFC assets pursuant to South Carolina Code annotated section 58-27-1300. Move that the Commission issue an accounting order permitting DEC and DEP to establish regulatory assets for the unrecovered net book value of the DCFC pilot assets, less any proceeds received from the sale of the assets. DEC and DEP shall amortize the regulatory assets in accordance with the terms of the stipulation and shall not earn a return on the unrecovered regulatory asset balances. Consistent with the stipulation, DEC and DEP may not recover site remediation costs from customers. Similarly, DEC and DEP intend to continue operating the DCFC assets until such assets are disposed of or sold. If the expenses to operate those assets are greater than the revenue received from them, such expenses may not be recovered from customers. As agreed in the terms of the stipulation, DEC and DEP must file a report with the Commission and ORS within 30 days of the sale or disposition of the DCFC pilot assets. Such report shall include the price, scope, and other relevant terms of the transaction or transactions. Further, I move the Commission request that a proposed order consistent with this directive be prepared and filed within 7 days. I so move.
Thank you, Commissioner Caston. Having heard the motions, any further discussion? Hearing none, we'll proceed to a roll call vote, beginning with Commissioner Caston.
Aye.
Commissioner Brett,
Aye.
Vice Chair Williams,
Aye.
and I vote aye, the motion carries.
Item number 6 is in docket number 2026-53E, and all commissioners are eligible to vote. This item involves final disposition of this docket.
All right, as to item number 6, is there a motion?
Chair Powers, I'm on a roll.
You are on the roll.
On February 13th, 2026, Duke Energy Progress, LLC, filed a request with the Commission for a light facility determination for the company's addition of the Birdtown Road 230 kV substation, the folding of its existing Robinson Plant Florence 230 kV line into the new Birdtown Road substation, the company's replacement of 4 existing structures with 5 new structures on the existing 230 kV line, the construction of a new Culpeper Solar 230 kV switching station, and a generation tie line from the Birdtown Road substation to the Culpeper Solar switching station. DEP states that Culpeper Solar LLC is responsible for the cost to construct these facilities and not the ratepayer. On March 5th, 2026, the Office of Regulatory Staff submitted its review letter to the Commission. While ORS did not object to the project, ORS did recommend that DEP file updates with the Commission and ORS on the project's progress and notify the Commission and ORS when the project is completed. I move the Commission find that the proposed construction of the DEP project constitute, in quotes, the replacement of an existing facility with a like facility, close quote, is authorized by South Carolina Code annotated section 5833 2024-110-1, and therefore does not constitute construction of a major utility facility, for which certification would be required under the Utility Facility Siting and Environmental Protection Act. I further move that DEP provide updates to the Commission and ORS every 3 months up to the completion of this like facilities project, and that DEP notify the Commission and ORS of the completion of this like facilities project within 10 days of its completion. I so move.
Thank you, Commissioner Caston. Before we vote on that particular item, I want to go back to number 5. I mistakenly overlooked the fact that all parties were eligible to vote. So I would like to record a vote of Commissioner Whitfield on item number 5.
I vote aye.
Commissioner Henley,
Aye.
thank you very much, and I apologize for that oversight. As to item number 6, all parties are eligible to vote. Is there any further discussion? Hearing none, all those in favor signify by aye.
Aye.
Those opposed by no, the ayes have it, the motion carries.
Item number 7 is in docket number 2025-325E, and all commissioners are eligible to vote. This is a petition from Mr. Stephen Olson to intervene in this docket, and a response in opposition to that petition from Dominion Energy South Carolina Incorporated.
As to item number 7, is there a motion?
Chair Powers,
Commissioner Caston.
I move that the Commission grant the request of Stephen Olson to intervene and participate as a party of record in this matter. Mr. Olson has complied with the requirements of South Carolina Code Annotated Regs 103-825. Mr. Olson has clearly stated the facts from which his rights and interests are derived, the grounds for his proposed intervention, and his position on the subject matter of this proceeding. Mr. Olson's intervention is limited to his personal interest in the matter. He is not authorized to represent the interests of an entire class of customers or any party other than himself. I so move.
Thank you, Commissioner Caston. Having heard the motions, any further discussion? Hearing none, all those in favor signify by aye.
Aye.
Those opposed by no, the ayes have it, the motion carries.
Item number 8 has been removed from today's agenda. Item number 9 involves opening a docket to address the study of the regulatory challenges and opportunities associated with the electrification of the transportation sector that is required by South Carolina Code Annotated Section 58-27-265, and all commissioners are eligible to vote.
As to item number 9, is there a motion?
Mr. Chairman.
Commissioner Whitfield.
Mr. Chairman, I move that the commission instruct the clerk's office to open a docket to study the regulatory issues related to the electrification of the transportation sector and report back to the Joint Committee on Electrification of Transportation and the General Assembly pursuant to South Carolina Code Annotated Section 58-27-265. So moved, Mr. Chairman.
Thank you, Commissioner Whitfield. As to this item, and the motion by Commissioner Whitfield, is there any further discussion? Hearing none, all those in favor signify by aye.
Aye.
Those opposed by no, the ayes have it. Motion carries.
Item number 10 appears in dockets number 2025-336C and 2025-337C, and all commissioners are eligible to vote. This is a request from Brightspeed Fiber Services LLC and Brightspeed Fiber Connection LLC to amend their applications for public convenience and necessity in these dockets.
That's item number 10. Do I hear a motion?
Mr. Chairman.
Commissioner Whitfield.
Mr. Chairman, on February 27th, 2026, Counsel for Brightspeed Fiber Connection LLC and Brightspeed Fiber Services LLC filed a request with the Commission to amend their respective applications. Specifically, the applicants seek to amend their applications by removing the request for the transfer and lease of certain assets. They do not request a change to the existing procedural schedule. On March 3rd, 2026, the Office of Regulatory Staff filed a letter with the Commission indicating that their review of the applications was ongoing and had not yet been completed, but they do not object to the applicant's request to amend. No other party submitted comments, and the amendment does not prejudice any party to this docket. Therefore, Mr. Chairman, I move that the Commission grant the request to amend the applications for certificates of public convenience and necessity in dockets number 2025-336C and 2025-337-C.
Thank you, Commissioner Whitfield. Having heard the motion, is any further discussion? Hearing none, all those in favor signify by aye.
Aye.
Those opposed by no. The ayes have it, the motion carries.
Item number 11 is in docket number 2023-132C, and all commissioners are eligible to vote. This item involves a letter from Dish Wireless LLC and Boost Subscriber Company LLC, doing business as Gen Mobile, requesting that the commission update its records to show that Boost Subscriber Co. LLC, doing business as Gen Mobile, is the correct name for the company's eligible telecommunications carrier designation in South Carolina.
That's to item 11. Do I hear a motion?
Mr. Chairman.
Commissioner Whitfield.
Mr. Chairman, I move that the commission accept the pro forma nature of the internal reorganization and continuity of ownership, control, and operations of Dish Wireless LLC, doing business as Gen Mobile, to update its ETC designation and to reflect the name change as Boost Subscriber LLC, doing business as Gen Mobile, so that the records indicate Boost Subscriber Company or Boost Subscriber Co. LLC, doing business as Gen Mobile, is the holder of the ETC designation effective immediately.
Thank you, Commissioner Whitfield. Having heard the motion, any further discussion? Hearing none, all those in favor signify by aye.
Aye.
Those opposed by no. The ayes have it, the motion carries.
Item number 12 is in docket number 2026-66C, and all commissioners are eligible to vote. This item involves appointing a hearing examiner in this docket.
That's to item number 12. Do I hear a motion?
I move that
Commissioner Henley.
the commission appoint attorney Adam Russell as the hearing examiner in the docket.
Thank you, Commissioner Henley. Haven't heard the motion. Is there any further discussion? Hearing none, all those in favor signify by aye.
Aye.
Those opposed by no. The ayes have it, the motion carries.
Item number 13 is in docket number 2005-83A, and all commissioners are eligible to vote. This item involves appointing Adam Russell, Esquire, as a standing hearing officer.
All right, that's to item number 13, and I hear a motion.
Yes, Mr. Chair.
Commissioner Henley.
I again move that the commission designate and appoint attorney Adam Russell, Esquire, as a standing hearing officer, which is note, the more than exceeds the qualifications and was overwhelmingly supported by his peers when we were getting my first briefing yesterday.
Thank you, Commissioner Henley. Having heard the motion, is any further discussion? All those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it, the motion carries.
Item number 14 appears in docket number 2025-253E, and all commissioners are eligible to vote. This is a motion from TOS SC Solar One LLC requesting oral arguments, clarification of evidentiary hearing procedures, and expedited relief.
That's to item number 14. Is there a motion?
Mr. Chair.
Mr. Vice Chair.
Mr. Chair, I move that the commission grant TOS Solar's motion requesting oral arguments on the issue of whether the commission should exercise its authority under South Carolina Code annotated sections 58-33-160, 160 paragraph 1 subparagraph E and 58-33-410 to preempt Sumter County's zoning, special exception requirement, and other local laws that relate to TOS Solar's application for a certificate of environmental compatibility and public convenience and necessity in this docket. Therefore, I move that the commission instruct the chief clerk to schedule the oral argument on TOS Solar's motion to take place at 9 a.m. on Wednesday, March 25th, 2026. I further move that the commission instruct the commission staff to hold a status conference with the parties to address any questions regarding the order of procedure, customer testimony, and calendaring additional hearing days should the commission need to hear evidence beyond March 26, 2026. So moved.
Thank you, Mr. Vice Chair. Having heard the motion by Vice Chair Williams, is there any further discussion?
Mr. Chair.
Mr. Vice Chair.
Thank you, Mr. Chair. Mr. Chair, I just want to note that I understand concern that the hearing may run longer than the scheduled time, but I feel fairly confident that you as the chair will be able to manage our calendar to accommodate any needs that may arise if the hearing does go longer than the scheduled time. Also, I think there's an opportunity for us to manage our time when it relates to the public testimony. I know that traditionally we allow public witnesses to testify longer than 3 minutes, even though our stated limit is 3 minutes. This may be an opportunity to maybe tighten down on that a little bit, considering that time may be an issue for all the parties involved in this matter. As the commission knows, we have a public hearing actually in Sumter County, and then we're also giving additional time for public witnesses to come to the commission or to call in or appear virtually before the commission on the day the hearing on the merits commences. So just offering that as some comments and encouragement that I think we'll be able to handle this matter in a timely manner. Thank you, Mr. Chair.
Thank you, Mr. Vice Chair. I agree with what you said. We will give the case a full hearing. Sometimes when we do have public hearings, the testimony becomes duplicative and seems to be written from a script, but we will allow everyone a chance to be heard. Having heard the motion, is any further discussion? Hearing none, all those in favor signify by aye.
Aye.
Those opposed by no, the ayes have it, the motion carries.
Mr. Chairman, that completes the utilities agenda before the commission. Moving on to the motor carrier agenda, in Part A, there's only one application for a new Class C certificate, and all commissioners are eligible to vote. Item A1 is in docket number 2026-54T. This is the application of Kellicor LLC, doing business as White Car Beaufort, for a Class E charter certificate.
As to item A1, is there a motion?
Mr. Chairman.
Commissioner Whitfield.
Mr. Chairman, I move that the commission approve the application in Kellicor LLC, doing business as White Car Beaufort, for a class charter certificate. This Class C charter certificate grants Kellicor LLC, doing business as White Car Beaufort, the authority to provide motor carrier services between points and places in the state of South Carolina, restricted up to 7 passengers, including driver. I move that the commission find that Kellicor LLC, doing business as White Car Beaufort, is fit, willing, and able to provide the service to the public as requested. I move the commission find that a certificate shall be issued by the Office of Regulatory Staff to Kellicor LLC, doing business as White Car Beaufort, upon the compliance with South Carolina Code annotated section 58-23-10 as amended, and applicable regulations for motor carriers, South Carolina Code annotated regs, volume 10, 2012 as amended, and requirements listed in exhibit attached to this directive, as well as the payment of all fees. So moved, Mr. Chairman.
Thank you, Commissioner Whitfield. Having heard the motion, is there any further discussion? Hearing none, all those in favor signify by aye. Aye. Those opposed by no, the ayes have it, the motion carries.
In Part B of the transportation agenda, there are 2 requests to cancel certificates that the commission may address together, and all commissioners are eligible to vote. Item B1 is in docket number 2024-110T. This is a request from Mokiorin Transport LLC to cancel Class C non-emergency certificate number 9920. And item B2 is in docket number 2025-94T. This is a request from 4 Points Limousine LLC to cancel Class C charter certificate number 10004.
Thank you, Mr. Scarborough. Is there a motion?
Chair Powers.
Commissioner Caston.
Thank you. I move that the commission grant the request for cancellation of the Class C certificates in agenda items number B1 and B2 as identified by Mr. Scarborough. A directive order will be issued in each docket granting the motor carrier's request for cancellation. I so move.
Thank you, Commissioner Caston. Having heard the motion, is there any further discussion? Hearing none, all those in favor signify by aye.
Aye.
Those opposed by no, the ayes have it, the motion carries.
Mr. Chairman and Commissioners, this concludes all business noticed before the commission today.
Thank you, Mr. Scarborough, and thank all of you who have joined us here and virtually. Have a very safe trip home, and be very careful with this weather. We will see you soon. We are adjourned.